Of the State of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with Ms. Brady, Ms. Higgs, and Ms. Nelson, and the people are represented by Mr. Orman, Ms. Stitch McGuire, Mr. Edson, and Mr. Edwards. The record should reflect that I took a break to give the parties an opportunity to review the amended introductory instructions. And these are the instructions that I intend to use at the introduction of the sentencing hearing. Before we get to them, however, I wanted to make a record about something. On Thursday, Mr. Orman asked me about setting a sentencing hearing with respect to the counts that are not subject to the capital sentencing hearing that's about to commence in front of the jury. These are the counts that I'm going to have to sentence the defendant on that are for attempted first-degree murder, attempted second-degree murder, and possession or control of an explosive or incendiary device. We have to set a hearing on those counts so that I can sentence the defendant on those counts. And I said that I would do that after the capital sentencing hearing is done, because I think we owe it to the jury to focus all of our attention and energy on the capital sentencing hearing, and I continue to believe that. But Mr. Orman had indicated that he was not requesting a PSI in anticipation of that that hearing on the counts that are not subject to the capital sentencing hearing. And the defense also indicated that it's not requesting a PSI. Colorado Revised Statute Section 16-11-1021A requires a PSI. This is a pre-sentence investigation report, and it's a report that's done by the probation department in anticipation of a sentencing hearing where the judge is going to impose sentencing. It requires a PSI for all felonies other than Class 1 felonies. However, Colorado Revised Statute Section 16-11-102 subsection 4 authorizes the court to dispense with the pre-sentence examination and report with the concurrence of the defendant and the prosecuting attorney. The only thing that cannot be waived, as far as I can tell, is the restitution information and the victim impact statements that may be presented at that hearing. So I just want to make a record that the prosecution is concurring and agreeing that the court should dispense with the pre-sentence examination and report. And I know I asked you on Thursday about this, both parties, but I think I asked in terms of whether they were requesting a PSI, as opposed to whether they're concurring and agreeing that the court should dispense with the pre-sentence examination and report. Mr. Orman?
Yes, Your Honor.
All right. And the defense, same question. Are you concurring and agreeing with that the court dispense with the pre-sentence examination and report? Yes, sir. Okay. Thank you, Ms. Brady. Okay, back to the instructions then. Actually, before we go on to the instructions, one other thing. At the end of the morning session, before we took the break, I said that the parties should submit to the court a proposed allocution advisement. And as I went back to the office, I remember that we had had a conversation about this, and sure enough, I asked my law clerks to look at the prior pleadings, and in P47, the people submitted a proposed allocution advisement. The defense responded to that proposal or proposed advisement, and I ruled on it. And so I've already addressed that issue. It's order P47, and I will follow that order in giving the defendant the allocution advisement. All right, back then to the introductory instructions. And again, these are the introductory instructions that I intend to give at the beginning of the sentencing hearing. As you can tell, folks, I have added some things in bold font, and I have indicated other things that I have deleted, again, in bold font to alert you to some of the changes that I made. I made these changes specifically based on my review of the defense's tendered introductory instructions and the defense's responses to the people's tendered introductory instructions. I had not had a chance to do that before I submitted the initial draft of these instructions to the parties on Friday, but I did get a chance to go through them on Saturday, and based on that, I made some changes on Sunday. So, on the first instruction, it starts with members of the jury. Now that the trial has been completed, we are starting the sentencing hearing. Mr. Orman, any objection with respect to this particular instruction?
Your Honor, on the 6th page, the court added in the first paragraph, the last or second to last line, in bold, the court added the words "are sufficient," and I don't really like that language, so I object to "are sufficient." I don't think that that's necessary. Additionally, Your Honor, there is on page 7, and I think elsewhere, in bold, this "and or information," and then you have a note to discuss that with counsel. My understanding of what that phrase means is that it's actually the allocution. Everything else is evidence. The information is the allocution, and the reason I say that is if you look at the allocution statute 1611-102 paren 5, it says the court shall afford the defendant the opportunity to make a statement on his or her own behalf and to present evidence in mitigation of punishment. So I think that that's the information. If you look at Davis, 794 Pacific 2nd 159, and the pinpoint is pages 191 and 192, Davis indicates that the allocution is not evidence, but it is something the jury can obviously consider. So I believe that the information outside of the evidence is, in fact, any allocution that happens. So if there is no allocution, I don't think the phrase "and information" is necessary. If there is allocution, I think it's appropriate. The question then becomes, should the defendant have the opportunity to allocute in Phase 2 as opposed to Phase 3? I would think Phase 3 would be the more obvious place to do it. But if you look at the statute, 1611-102 paren 5, it does talk about in mitigation of punishment. So because I don't think that statute was drafted with the penalty procedure in mind, but it does talk about in mitigation of punishment. So I think that the defendant probably has a statutory, not constitutional, right to allocute in both Phase 2 and Phase 3. So I think you would need to be given the allocution advisement at both times because of the statute, not because of any constitutional right. But regardless of the origin of the right, I think that the Colorado law is affording that to him. So he also, I think, has the right to testify in all 3 phases, and I think that needs to be a standard Curtis advisement for each phase. So I know it's probably going beyond what Your Honor asked, but because that language was in the instruction, I thought I would just bring that up.
No, I appreciate you doing that. Thank you for doing that. The reason I said in this draft, discuss with counsel, is because I do want to discuss it with you. What happened is that in individual voir dire, to the best of my recollection, we all kept saying to the prospective jurors at that time, you have to make decisions based only on the evidence and information presented in the courtroom. And so that admonishment kept being given by the court. At some point during the trial, I made it clear to the jurors, hey, for your purposes right now in terms of the guilt phase of the trial, when I say evidence and information presented in the trial, I mean evidence presented in the trial, because for purposes of the guilt phase of the trial, or the first part of the proceedings, the trial proceedings, the jury must make all decisions based solely on the evidence. And so I kept wondering about this language related to information that I know we've all been talking to that we all talk to the prospective jurors about in terms of sentencing or a sentencing hearing. And so I wanted to talk to the parties about that and how we treat that and how we clarify that for the jury. So I appreciate Mr. Orman addressing the court, and I'll hear from the defense about that in just a moment. But that's helpful. In terms of allocution, we have to keep in mind that we have tricated, if you will, not trifurcated, not bifurcated, but trifurcated, if you will, the proceedings in this sentencing part. The statute doesn't talk about that. The statute does not say, the proceedings are divided into three. But the case law clearly talks about different phases. And I think it's too much to ask of jurors to do this all in one shot. I just think you're asking for trouble. And nobody that I can remember disagreed with the court's decision to trifurcate or to split the proceedings into three phases. And I think it makes sense to do it the way we're doing it. But given that, I think we have to be careful about something like the right of allocution. And I agree with Mr. Orman that the defendant would have that right both at the end of phase or in phase 2 as well as in phase 3. In phase 1, I don't think it applies, but in phase 1, at a minimum, he obviously has to be given the courteous advisement. If the defense believes that the right of allocution applies in phase 1, I'll hear from the defense on that. But I think at a minimum, it applies in phase 2 and in phase 3, the way we're doing the sentencing hearing. So that's why I wanted to discuss that use of the word information with both parties. In terms of page 6 and saying are sufficient, it doesn't bother me to have that in there. I'm the one who added it. That's consistent with my comments in individual voir dire, but I'll hear from the defense on that. Is there anything else, Mr. Orman, that you want to talk about before I move on to see what objections the defense has with respect to this particular instruction? All right. Ms. Nelson?
Mr. Orman's concerns first?
Everything, however you want to proceed.
My issues will touch upon the issues that he raised, so maybe we should just start from the beginning, and then when we get there, we can talk about my thoughts on those particular issues that he raised.
Okay.
So, on page 1, we maintain our position on the issue of merger, and so every place where it says 24, we think it should say 12. We don't object to the defendant has been found guilty of 24 counts of murder in the first degree, but then we maintain that they should be instructed that those counts merged and that they're determining the punishment for each of the 12 first-degree murder convictions.
Okay. I'll stick with my ruling for now, but I will look into that further, as I said before. What else?
And then if I may just have a moment. I'm trying to compare the different drafts and then my prepared remarks, which were based on the earlier draft. So.
And before I forget, as Ms. Nelson is doing that, if anybody thinks that it's a mistake to do this in three phases, now is the time to tell me, because I know I've told the jury we're going to do it in three phases, but if somebody thinks, oh, Judge, this is wrong, this is a mistake, obviously that's something that should have been brought up before. But, I can always change my mind and tell the jury, hey, folks, we're going to do it in one phase, and then we'll proceed. But, I think that's a mistake. So, what else, Ms. Nelson?
With respect to the second page of the instruction,
yes,
the first full paragraph, a death sentence is never mandatory or required. The law never requires a death sentence. We don't have any issue with that. We would just ask that the court consider adding a sentence following that stating the law is always satisfied with a sentence of life without parole. The reason being that we think it's important, given the heightened reliability that applies to capital sentencing proceeding under the 8th Amendment and Article 2, Section 20 of the Colorado Constitution, that the jury understands that a life sentence is always an appropriate verdict to render.
The problem I have with that sentence is I don't know what it means. and I find it confusing. And if I don't know what it means, at least some people on the jury may not understand what it means. If the point is that a death sentence is never required or mandatory, and that the law never requires a death sentence, then I'm telling them that. I don't know what it means to then add that the law is always satisfied with a life sentence. What exactly does that mean? Does that mean that they're not required to return a death sentence, and that it's okay under the law for them to return a life sentence? The law will not be offended or violated if they do that? Well, we're telling them that already. So I find that sentence confusing. I know that was in your tendered instructions, and I know that comment has been made in the past in individual voir dire by defense counsel. I just don't know exactly what that means. Do the people have a position with respect to that sentence?
Your Honor, I don't know what it means. I don't think it's appropriate, and I don't think it makes grammatical sense. I mean, if you think about the verb satisfied, the law is not a living being to be satisfied with anything. The law is not even a corporate entity. The law is just the law. The law cannot take the action of being satisfied. I don't know what it means, and I think the instructions from the court are extremely clear.
All right, Ms. Nelson, what else?
And then if the court has an issue with that specific proposed language, we would ask the court to consider including language in our proposed instruction number 45, which states, in any case in which the death penalty is sought, a juror may always vote for a life sentence without the possibility of parole based upon evidence and mitigation, mercy, or any other reason.
Again, I think that's going to be clear to the jurors by these instructions. I don't think any juror is going to be under the misimpression that they're not able to vote for a life sentence. So I think that's abundantly clear from the instructions. So the request is denied. What else?
Then we would ask somewhere in that second page, perhaps after that first full paragraph, that the court include language from our proposed instruction 43, which pertains to the presumption of life. If the court has a concern about the particular term presumption of life, which I know this was an issue that was discussed in People v. Tennyson, we would ask that the court consider stating that Mr. Holmes is entitled to a presumption that he should not be put to death as punishment for this offense. The law requires that each and every one of you be convinced beyond a reasonable doubt that death is the only appropriate sentence before you may impose a sentence of death.
What's the people's position, Mr. Orman?
We object, Your Honor. There is no such presumption. I mean, obviously, the jury needs to be informed that they need to be satisfied beyond a reasonable doubt in Phase 3 that death is the appropriate sentence. But there is no burden of proof, and I think the defendant's language implies that there is.
I agree. I looked at that from your tendered instructions, Ms. Nelson, and even the part that you cited or you quoted from Tennyson didn't quite support the language that you're asking the court to instruct the jury on. I think Tennyson was discussing something, and in passing, it made a comment about that, but I didn't read that to mean that there is a presumption with respect to a life sentence, much less that the court should instruct the jury on such presumption. Let me just find your instruction, your tendered instruction real quick. here's the language that you quoted from Tennyson. Because we hold that the jury must be convinced beyond a reasonable doubt that any mitigating factors do not outweigh the proven statutory aggravating factors, there is in some sense a presumption that the mitigators do outweigh the proven statutory aggravators, and therefore a presumption favoring a sentence of life imprisonment. To the extent that an instruction embodying a presumption of life imprisonment expresses no more than that before a death sentence can be imposed, the jury, no more than that before the sentence can be imposed, the jury must be convinced beyond a reasonable doubt that the sentence should be imposed. It correctly expresses the law. The instructions given in the cases before us meet this test. I'm reading from your tendered instructions and specifically your quote from Tennyson, but then as you acknowledge, right after that it says, the court in Tennyson stated that the better practice is to avoid the use of that term because it has the potential for confusing the jury. And I agree. I think that telling the jury that there's a presumption of a life sentence confuses the jury. Number one, that the people have to overcome that presumption and that therefore they have a burden of proof, or number two, that they themselves have to overcome that presumption, and that's not the case. I think that what needs to be conveyed to the jury is that they can only return a sentence of death if they are convinced beyond a reasonable doubt that death is the appropriate sentence, and that is exactly what I plan on instructing them on and what the introductory instructions say. So that request is denied. What else?
Still on the second page, second paragraph, the sentencing hearing may consist of up to 3 phases. The purpose of the sentencing hearing is to determine the appropriate sentence to be imposed upon the defendant on each of the 24 counts of murder in the first degree. Again, we maintain our merger argument and maintain our position that it should be 12 convictions. But in addition, we would ask that the court give our instruction 44, which states the purpose of the sentencing proceeding is to determine the appropriate punishment for Mr. Holmes based on his individual personal moral culpability. In other words, the punishment should fit the person who committed the crime. And your sentencing decision should not be based solely on the nature of the crime itself. And this instruction is really based on this focus on the defendant's individual moral culpability that is an important part of the United States Supreme Court's Eighth Amendment jurisprudence and the Colorado Supreme Court's jurisprudence under Article 2, Section 20 of the Colorado Constitution. We think this instruction is required by the heightened reliability standard required by those constitutional provisions, especially in a case of this magnitude, that we think that the court needs to give the jury an instruction explaining that it's individual moral personal culpability that's ultimately at issue in the sentencing proceeding. So that would be our request.
I have a similar statement elsewhere in the instructions under Phase 2 and under Phase 3 both. I say you must treat the defendant as a uniquely individual human being, and you must not consider any public opinion or community sentiment for or against him. And I think I did that based in part on, well, that may have been on my own before I looked at your tendered instructions because it's not in bold, but I felt that was already in there, that they have to treat the defendant as an individual, as a uniquely individual human being, and that they cannot consider any public opinion or community sentiment for or against them. So I think that's the concept that I get from your tender instruction. The concern that I had with your tender instruction is that, I don't want to confuse them in terms of what their sentence should be based on. And later I addressed that in more detail. I addressed that in Phase 2 and in Phase 3 in terms of what exactly goes into their determination for purposes of each phase. And it talks about morality in there, and it talks about reason moral judgment more specifically. So I think it's more appropriately dealt there. The main point that I inferred from this standard instruction 44 was that the defendant is an individual, and he should be treated as an individual. And I think that point is made elsewhere in my instructions. I didn't see anything else that needed to, that was appropriate to include in the instructions. Again, my concern was saying that the decision has to be based on the defendant's personal moral culpability, is that I think it could confuse the jury. I don't think I don't think it is a complete statement of the law, and I think it's treated elsewhere in the instructions better in any event. So what's next?
Next, in that same paragraph, we object to the portion of the instruction in that paragraph that begins, further, the court reminds you of your obligation to be fair and impartial jurors, and continuing on into the remainder of that paragraph. Our concern with the language, in particular, fair to both sides and neutral, is that's very confusing to the jury. And the reason is that the jury doesn't have to start out in this neutral place and then be somehow convinced down to a life sentence. They don't have to be convinced of anything to impose a life sentence. They have to be convinced of something to impose a death sentence. And so to tell them that they have to be neutral going into the proceedings, we think is an inaccurate statement and also very confusing to them.
I had added that for your benefit, but I'm happy to take it out. If you don't want it in there, I'm happy to take it out. Do the people have a position on that, Mr. Orman? And also, by the way, did you have a position on the last change or the last discussion we had with respect to proposed instruction number 44?
I object to the language in 44, and I think the language that the court has in its proposed instruction is appropriate. Your Honor, I find it interesting that the defense had previously wanted an instruction where the jurors were to tell the court if they had any inclination or any opinion about what the punishment should be at this point, and now they're saying that the jurors don't have to be fair and neutral. That seems somewhat contradictory to me. I think the jurors do have to be fair to both sides and neutral, and I think this language is appropriate.
And it's something that I talked to them about in individual voir dire as well, and I do think that that's what, I mean, we can't have jurors who are going into the sentencing hearing already thinking that this should be a life sentence. There's no authority for that. There's no basis for that in the law.
Well, and I guess that's where we just have a disagreement, Your Honor, because our position is that is, I mean, just like the presumption of innocence, it's not improper for a juror to come into a trial presuming a defendant innocent. It's also not improper for the jury to go into the sentencing phase presuming that a life sentence is the appropriate sentence rather than a death sentence, because they have to be persuaded or convinced beyond a reasonable doubt before they can impose a death sentence. But the same does not apply to a life sentence.
All right, I'll take that sentence out.
We would ask that instead,
Actually,
and then
I have to take the two sentences out because there's another one that comes after that.
Yes, and our concern with that sentence is just by telling the jury that their obligation to be fair and impartial no longer relates to the issue of whether Mr. Holmes is not guilty by reason of insanity. Our concern, obviously, is that the mitigation in this case there's a large portion of the mitigation in this case also pertains to some of the similar issues that were raised by his plea of not guilty by reason of insanity, mainly the issue of his mental health.
Okay, for the record, here are the four sentences that I think have to come out based on the defense's objection and specific request to have the court take this out. It would have read as follows. Further, the court reminds you of your obligation to be fair and impartial jurors, fair to both sides and neutral. Your obligation to be fair and impartial no longer relates to the issue of whether the defendant is guilty, or not guilty by reason of insanity. You have determined that issue already because you have found the defendant guilty on the 24 counts of murder in the first degree submitted to you at the end of the trial. The only unresolved issue now is what sentence is appropriate on each of those counts. And I disagree that there is this presumption that is similar to the presumption of innocence. It's not that simple. The prosecution doesn't have a burden of proof for the entire sentencing hearing. They have a burden of proof with respect to aggravators. They have to prove beyond a reasonable doubt at least one aggravator. That's it. If they get past that phase and we get into phase 2 and phase 3, there's no burden of proof. And, at that point, it's true that in order for the jury to impose a death sentence, the jury has to be convinced beyond a reasonable doubt that death is the appropriate sentence. And at the end of phase 2, the jury has to be convinced beyond a reasonable doubt that mitigation does not outweigh aggravation. But I don't think that's the same thing as saying, well, at the beginning of the sentencing hearing, folks, you should be already leaning toward a life sentence, and you should only move from that position if the people prove to you beyond a reasonable doubt that you should. It doesn't work like that. That's not my understanding of the law. So, but in any event, since the defense is asking me to take these 4 sentences out, I will take them out. What else, Ms. Nelson?
We would ask that actually in its place the court consider giving the rest of our proposed instruction 47, which starts out similar to the sentence that the court's leaving in, which is that you must consider the evidence presented and the arguments of the attorneys with an open mind, and then goes on to say it's your sworn obligation to withhold any judgment and decline to form any opinion about the matters at issue during each part of the sentencing trial until after you've heard the evidence presented, etc.
The reason why I didn't include that instruction is, number one, the having an open mind, I think may be in here already, but I'm going to be giving them admonishments, and one of the admonishments that I will be giving them is similar to the one I've been giving them throughout the trial, or that I gave them throughout the trial, and that is that they have to keep an open mind, and that they cannot start forming opinions yet, and that they have to base their decisions solely on the evidence and information presented in the courtroom and the instructions of law that I provide. So I just didn't see the need for this particular instruction, given that I'm going to be providing those admonishments. Mr. Orman, do the people have a position on this instruction?
I don't like that language presented by the defendant. I think the language that the court originally had in here, which it's taking out at the defendant's request, is much more accurate and fair.
All right, and Ms. Nelson, even though I'm denying your tender instruction 47, you're still asking me to omit the last 4 sentences of the second full paragraph on page 2 of this draft of the introductory instructions. Is that correct?
Yes, Your Honor.
Okay, what else?
Next on page 3, in the court's description of phase 1, we would just ask the court to amend the second sentence to add, as to each count, and then add, in order for you to find the existence of an aggravating factor, the prosecution is required to prove beyond a reasonable doubt the existence of at least one of the aggravating factors that is alleged in this case. I think that just makes it clearer that it's not that the court's requiring the prosecution to prove this. It's that in order for them to find it, the prosecution's required to prove an aggravating factor beyond a reasonable doubt.
Mr. Orman?
I don't have a position on that, Your Honor.
Alternatively, we would also be okay with the court just saying as to each count the prosecution is given the opportunity to prove. But I think I prefer the first proposal that I articulated.
I think your initial proposal makes it more confusing, not less confusing or not more clear, and so I'll deny that request. If the alternative is to say the prosecution is given an opportunity, because you think that by saying the prosecution is required, that's going to convey to the jury that I want them to prove this? Is that what your objection is? I don't even follow that objection. You think that because I tell them the prosecution is required to prove something, that means that it's me wanting them to prove it?
It's just incomplete because the prosecution is required to prove it in order to move to phase 2, essentially. Or they're required to prove it if the jury is going to find it. But just saying that they're required to prove this, I don't think that's enough. I think the court has to say, in order for you to find it, the prosecution is required to prove it. And then the jury is going to find it. But just saying that they're required to prove this, I don't think that's enough. I think the court has to say, in order for you to find it, the prosecution is required to prove it. And then the jury is going to find it. But just saying that they're required to prove this, I don't think that's enough. I think the court has to say, in order for you to find it, the prosecution is required to prove it. And then the jury is going to find it. But just saying that they're required to prove this, I don't think that's enough. I think the court has to say, in order for you to find it, the prosecution is required to prove it. And then the jury is going to find it. But just saying that they're required to prove this, I don't think that's enough. I think the court has to say, in order for you to find it, the prosecution is required to prove it. And then the jury is going to find it. But just saying that they're required to prove this, I don't think that's without anything else, I mean, they're required to prove it if they want to pursue the death penalty against Mr. Holmes.
But that's made clear elsewhere in the instructions. I mean, it's made abundantly clear that we only move to phase 2 if the prosecution meets its burden of proof. On the next page, it says, at the end of phase 1, the jury will deliberate. If the jury does not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one of these aggravating factors with respect to a count of murder in the first degree, the jury must render a sentencing verdict of life imprisonment without the possibility of parole on that count. On the other hand, if the jury unanimously finds that the prosecution has proven beyond a reasonable doubt at least one of these aggravating factors with respect to a count of murder in the first degree, the jury must render a verdict that reflects that finding, and the sentencing hearing will continue to phase 2 on that count. So I think the instruction as is better than it would be with the either of the requested or proposed suggestions. So what's next?
On the next page, at the bottom of page 4, we maintain our request that we made with respect to the last instruction that was discussed in the court's final proposed instructions, as well as the verdict forms regarding the jury must render a sentencing verdict of life without parole on that count. We think it should read, if the jury does not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one of these aggravating factors with respect to a count of murder in the first degree, Mr. Holmes will be sentenced to life imprisonment without parole on that count, or on that conviction. I understand the court, I understand what the court is saying about the statute.
All right, same
But
ruling as before.
that's our
What I
position.
will do, though, I will put a comma at the end of the sentence, and then it'll say, and the court will sentence the defendant in accordance with that sentencing verdict. Actually, it should say, and the court will sentence the defendant on that count in accordance with the sentencing verdict.
And then, consistent with the language in our proposed instruction 46, we
Yes.
would ask that the court include something at the end of that paragraph. Now, I know that we've already talked about the court's and the prosecution's feelings about the phrase, the law is satisfied with a verdict like that, but we think it's important to somehow convey to the jury that it is okay, perfectly acceptable under the law, for the sentencing hearing to stop after phase 1 or stop after phase 2, that there's no requirement that it has to go all the way through phase 3. We think that's especially important to convey to them at the end of every phase, that it's not that the sentencing hearing would somehow be incomplete if they didn't go through the entire, all 3 phases.
Is it okay with the law? Is the law satisfied if it does continue to?
Well, it is, and I think that that's obvious from the rest of the court's instructions, but I think it's also the case that there is no requirement that they continue on to phase 2 or phase 3. So
I think that point is clear. I think it's clear that it's okay for them to vote one way and have the sentencing hearing end, and that it's okay for them to vote a different way and have the sentencing hearing continue. I don't think I need to say to them, the law is satisfied if you do one thing, and the law is satisfied if you do another thing. If I'm going to tell them that the law is satisfied with respect to one particular decision, I have to tell them that it's satisfied with respect to the other type of decision, and I don't see the need for to do that, because that point is clear throughout the instructions. What else do you have?
if I may just have a moment to reconcile my
Yes.
lists. I think that the court, on page 5, I think the court's amendment to that first paragraph takes care of what I was going to say
Okay.
about that. We would ask again that it be with respect to a conviction instead of count, based on our merger argument.
All right, and again, I stand by my ruling, but if I change my mind, I'll let you know. I do think that it's simpler to talk about counts because they're used to counts now as opposed to convictions, and it's consistent with what they've been hearing throughout, but I'll look at the merger issue more in depth.
And then on the same page, page 5, with respect to phase 2, we would ask that the court incorporate some of the language defining mitigation that's contained in our instruction 46, and particularly and at a minimum, just to explain that mitigation can come from any source. It doesn't have to come from the defendant. And
Hold on.
okay.
Do the people have any objection to that?
It's got to come from something in the trial, Your Honor. I mean, it's any evidence, and it doesn't have to come from the defendant. It can be evidence that we presented, but I think that if any source implies that they could go, read a book or listen to a song on the radio as they're driving into work, and that's somehow something that they can consider. It's not. So I think that the way the court has drafted this, it conveys the law correctly. In fact, it conveys it very beneficially to the defendant in this paragraph. It even says that the law, the jury has to give full consideration and effect to all mitigation presented without even mentioning that it really has to be mitigation that they find exists. They have to listen to everything, but it's mitigation that they find is present. They don't have to find any mitigation present that is presented to them. So I disagree with the suggestion by defense counsel.
And Your Honor, if I can just respond.
Yes.
I mean, we disagree that mitigation has to come from the evidence. I think that our position on that should be clear from the arguments and instructions that we've submitted to the court, because it can come from a juror's own individual, personal, moral conviction, however, and from a place of mercy. However, for the purposes of this instruction, the way that we proposed phrasing it is on page 13 of our proposed instructions, which is our defense 46. In the event this case reaches phase 2, Mr. Holmes may, but is not required to present evidence of mitigating factors, although the jury must consider all evidence of mitigation regardless of who presents it. Okay. Another way of doing it would be the way that the court did it in its video script.
No, I like that sentence is fine with me. So I'll add that. But I agree with you that in part the jury can consider mercy. I agree that in part this is a moral decision, but it has to be anchored or based on evidence. It can't just be, or something presented in the courtroom such as a defendant's allocution. It can't just be that a jury comes in and says, well, I'm going to vote for a life sentence, not because of anything presented in the courtroom, but because I just, on my own, feel morally that I can't vote for a death sentence. That's not what the law is. That's a whole point of why we took 2 months or however long we took to do individual voir dire, because we can't have people who come in and say, I'm going to come into this already thinking that I'm in favor of the death penalty, or I'm coming into this already thinking I'm in favor of the life sentence. It has to be something that has some basis in the evidence presented or in the information presented in the courtroom that they can consider, that I specifically tell them that they may consider. So, but I will add the language in that first sentence. So I will modify my language to reflect what is what you have in your first sentence on page 13 of your tendered instructions at the beginning of the discussion of phase 2. What else?
And we would also ask, I know that on the next page, the court has, on page 6, the court says neither party has a burden to prove anything in phase 2.
Yes.
But we think it would be appropriate on the previous page at some point, maybe in that first paragraph, to stress that even there's no burden on Mr. Holmes to present any mitigating evidence at all or to prove the existence of any mitigating factor to any degree of certainty. Or just to make it clear that he doesn't have any burden to prove anything, even if he chooses to present mitigation.
What do the people think about that?
I think you already say that, Your Honor. On page 5, under Phase 2, it says, in Phase 2, if there is a Phase 2, the defendant may, but is not required to, present mitigation. So,
And then I say on page 6 that neither party has the burden to prove anything in phase 2. So it's repeated twice. It's mentioned twice. What else do you have, Ms. Nelson?
Our next concern or request is that we think it's a bit confusing and not necessary to distinguish between statutory mitigators and non-statutory mitigation in that second paragraph about phase 2.
I was trying to be consistent with what I said about aggravators, because in aggravators, I talked about statutory aggravators, and we've talked about that in individual voir dire as well. So, I mean, I'm not aware of any non-statutory mitigating factors. They're all statutory mitigating factors. Now, it may be something that's not specifically listed in the statute, but it's still a statutory mitigator because the statute says that anything that's favorable, basically anything that could cause a juror to, or that might cause a juror to vote for a life sentence can be considered a mitigator. So that's still a statutory mitigator. But if you want me to take it out, I'll take it out. I just was trying to be consistent so that they don't think, the jurors don't think, well, there's a statute on aggravators. Apparently, there's not a statute on mitigators. Yes.
Perhaps it would clear it up if you left those two sentences in.
What page are you on?
I'm sorry, page 5,
Okay.
second paragraph under phase 2, where you say, in other words, if we included, in other words, mitigation is any evidence that might cause a juror to vote for a life sentence.
I don't have a problem with that. Do the people have a problem with that? All right, that's fine. What else?
Okay.
Are you okay with are sufficient on page 6, or do you want that out as well? That's in the first incomplete paragraph at the end. Each juror must then individually decide whether the mitigating factors are sufficient to outweigh the aggravating factors. Mr. Orman is asking that it read, each juror must then individually decide whether the mitigating factors outweigh the aggravating factors.
I disagree with Mr. Orman. I think that's a misstatement of the law under People versus Tennyson. I'm concerned about are sufficient as well. Now, I know that this language technically tracks the statute, But in People versus Tennyson, the Colorado Supreme Court specifically interpreted that statutory provision to mean that in order to impose a sentence of death, the juror must be convinced beyond a reasonable doubt that the mitigation does not outweigh the aggravation. And so our position is that it has to be phrased exactly like that. And the concern is that by saying each juror must then individually decide whether the mitigating factors are sufficient to outweigh the aggravating factors. Number one, there's nothing in there beyond a reasonable doubt. But number two, it implies that in order to stop and not proceed to phase 3, they have to make an affirmative finding that the mitigation outweighs the aggravation, when in fact the Tennyson standard is intended to it's intended for any reasonable doubt about the outcome of the weighing process to inure to the benefit of the defendant. I fully admit it's a confusing concept to wrap my head around. It took me a long time to sort of figure out whether there was really any semantic difference, but there is a semantic difference, and I think that we need to adhere very closely to the very specific language articulated by the Colorado Supreme Court in People versus Tennyson.
But I'm looking at the statute, and the statute says whether sufficient mitigating factors exist which outweigh any aggravating factor or factors found to exist.
Right, I
So
understand.
this is consistent with the statute.
Well, but Tennyson interpreted the statute, and so I think that we are bound by the Colorado Supreme Court's interpretation of what that statute means and the standard by which jurors are to determine whether that statutory provision has been fulfilled or not.
But Dunlap interpreted the statute too, and I don't remember Dunlap interpreting the statute in that fashion. I remember Dunlap giving the statute its plain meaning. No?
Well, our position is that under Tennyson, it has to state each juror must then individually decide whether he or she is convinced beyond a reasonable doubt that the mitigating factors do not outweigh the aggravating factors.
Well, Dunlap came after Tennyson, so it's more recent than Tennyson.
I mean, I'd have to look at the specific part of the Dunlap opinion the court's referring to, but I don't take anything in Dunlap to be overruling the Colorado Supreme Court's ruling in People versus Tennyson.
What's the people's position, Mr. Orman?
I think if the court wants to track the language of the statute, I think the court indicated it's whether sufficient mitigating factors exist. It should be ordered the same way. Frankly, I don't really think it makes much of a difference to say whether the mitigating factors outweigh the aggravation or whether they have to find beyond a reasonable doubt that they do not outweigh the aggravation. I think it's much more confusing to put it the way the counsel is suggesting, but frankly, it really doesn't matter to me. If the court wants to do it the way counsel is suggesting, that's fine with me.
Okay, so you're okay with the way Ms. Nelson is asking?
Yes.
Okay, all right. Ms. Nelson, tell me again, how is it that you want to change it?
Okay, so I'm just reading directly from Tennyson.
Right.
And it says that Colorado's death penalty statute must be construed to require that the jury must be convinced beyond a reasonable doubt that any mitigating factors do not outweigh the proven statutory aggravating factors. So in the context of this sentence, it would state, each juror must then individually decide for him or herself, individually decide whether he or she is convinced beyond a reasonable doubt that any mitigating factors do not outweigh the proven statutory aggravating factors.
All right, I'll take another look at Dunlap, and then I'll decide how to proceed. All right, what else?
And may I give the court the pin site to People versus Tennyson?
Yes, what page is that?
It's 788 P. 2nd, 786, and the pin site is, well, it's repeated throughout the opinion, but the specific language I was reading from comes from page 795.
Okay, what else?
If I may just have one moment. Just to backtrack a little bit, because we skipped ahead to the end of that paragraph. Up at the top of that paragraph, the court's language in the second sentence, the jury need not unanimously agree on which mitigating factors exist or even that any mitigating factors exist. We would ask the court to give our language on page 14 of instruction 46. The law states that it is not necessary for jurors to unanimously agree about whether a mitigating factor exists before it may be considered by any individual juror.
You like that better than what I have here right now?
Yes.
Okay, that's number 46. What page, what part of 46?
Page 14 of instruction 46.
And what part of the page? Oh, the law states that it is not necessary.
Yes.
Do the people have any objection to that?
I don't have so much of an objection, but I think the way the court has it in this instruction is much more clear, and I prefer the court's language.
My sentence is more complete. I mean, my sentence says the jury need not unanimously agree on which mitigating factors exist or even that any mitigating factors exist. If you're worried about the part about the law, I can add that and say under the law, the jury need not unanimously agree. Is that part of the concern that it doesn't refer to the law?
No, it's more of a phrasing issue. The court, I have a second proposal for the court, which is the way that the court described it in its language in the video.
Okay.
Which would be the jury need not unanimously agree that mitigating factors exist or that the same mitigating factors exist, which I think conveys the same thing but
Okay, I'll do that.
states it a little more clearly.
Okay. And that, going back to that Tennyson language, I remember now that this was a point of contention before the videotape remarks. I still don't see the difference that you're seeing in the language. I think it's semantics. I still don't get what difference there is between the way Tennyson said it and the way the statute is. I don't think Tennyson meant to rewrite the statute. And they never, in Tennyson, said that they were rewriting the statute. And I don't think Tennyson is inconsistent with Dunlap. I think they're saying the same thing. They're using different language to say it. But I'll look at it again, and I'll use your language if you want, but I don't think that there's a difference. I don't think it's a distinction with any significance. All right, what else do you have, Ms. Nelson?
Then the next sentence, each juror must then individually decide what weight to give each mitigating factor that he or she determines exists. In other words, each juror must decide how much weight each such mitigating factor deserves, and then the jurors engage in the weighing process. As I was reading this, I felt that it was a little bit confusing and perhaps inaccurate to say that the jury predetermines a weight and then engages in the weighing process, rather than having the weighing process itself is where that weight is determined, if that makes any sense. It's not like the jury, has to assign a certain aggravator or mitigator a particular value in advance and then engage. It almost makes the weighing process itself redundant because they've already assigned particular weights to particular factors. I think they make their determination in step 2 about what mitigation exists, and then they just engage in the weighing process.
Well, I don't know how you can engage in the weighing process if you don't know how much the mitigating factors weigh. If you haven't thought about how heavy the mitigating factors are, then how can you weigh the mitigating factors with anything, right? Don't you have to first know how much they weigh?
I think that occurs during the weighing process.
You just think it's
That's-
one process as opposed to a two-step process.
Yes.
All right, so do you want me to just delete the sentences?
That would be our request.
So you wanted to just say each juror must engage in what the law refers to a weighing process. Each juror must weigh the mitigating factors that he or she has determined exist against the aggravating factors proven by the prosecution beyond a reasonable doubt in phase one.
Well, and then we would also ask that the court includes some language about, I think this is also included in R46, that the weighing process is not a mere counting process, and that their decision should not be mechanical or mathematical.
All right, Mr. Orman, what's the people's position with respect to those two requests?
Well, look, Your Honor, I don't mind taking that sentence out.
It's actually, yeah, it is one sentence. Each juror must then individually decide what weight to give each mitigating factor that he or she determined exists. In other words, each juror must decide how much weight each such mitigating factor deserves. So because the defense is specifically asking me to take that out, I will take it out.
And I think the other sentiment that counsel wanted you to put additional language in is adequately covered by this instruction, so I would object to adding that.
And on that issue, Your Honor, I know there's case law about this. I know People versus Davis discusses this.
What part of your instruction is that in?
I can find it for the court. It's page 14, second paragraph.
Okay, what part of the paragraph?
Second sentence. Second sentence, third sentence, fourth sentence.
The weighing process is not a mere counting process. A single mitigating factor may outweigh all proven aggravating factors. Your decision should not be mechanical or mathematical. Instead, with respect to each conviction of first-degree murder, each juror must make an individual reasoned moral judgment whether he or she has been convinced beyond a reasonable doubt that the mitigating factors do not outweigh the aggravating factors. The last sentence is, you're not asking me to add because it's already in there, but the other two you are, right?
Yes.
Okay.
Well, actually, in the last sentence, I think we would ask that the last sentence replace what the court has because we think it's compliant with Tennyson in our instruction.
May I?
Yes.
If you're going to add that, it is true that a single mitigating factor can outweigh all the aggravating factors. It is conversely true that a single aggravating factor can outweigh all the mitigation. So if that court is inclined to include that sentence that counsel is suggesting, I would request a sentence that says, conversely, a single aggravating factor can outweigh all the mitigation. It's not mathematical. That's true. But, to just say it one way and not the other would be grossly unfair.
Okay, I think that's a fair request. So I'll add the two sentences, Ms. Nelson, in your proposed instruction, and then I'll add the people's requested language as well. So let me just make a note of it.
I think it's 3 sentences, Your Honor, if the court's willing to give all 3.
It starts, this weighing process is not a mere counting process, right?
Well, just a moment, Your Honor. Actually, I have just... Your Honor, our position is that if the court's going to add Mr. Orman's proposed language, then we would strike our request to include. We object to that, and so if that's, we would instead just ask that the court say this weighing process is not a mere counting process, and just omit the single mitigating factor may outweigh all proven aggravating factors.
Okay, so I'll say this process is not a mere counting process.
And perhaps your decision should not be mechanical or mathematical.
All right, I'll add that as well. In terms of the next sentence, your decision should not, instead, with respect to each conviction of first-degree murder, each juror must make an individual reasoned moral judgment whether he or she has been convinced beyond a reasonable doubt that the mitigating factors do not outweigh the aggravating factors. I have indicated on page 7 of my draft instructions that both, it says actually, in reaching your decisions during phase 2, you must not be influenced by prejudice or bias of any sort against the defendant. You must treat the defendant as a uniquely individual human being, and you must not consider any public opinion or community sentiment for or against him. A juror must use his or her individual reasoned moral judgment during this phase of the sentencing hearing. Further, each juror may consider mercy for the defendant during phase 2. So the concepts in that sentence are, I think, already included on page 7 of my draft instruction. And then the last sentence of the first incomplete paragraph on page 6 of my instruction reads, each juror must then individually decide whether the mitigating factors do not outweigh the proven aggravating factors. That's at least based on the language that Ms. Nelson requested that I use, which Mr. Orman didn't have any objection to. I think that's from Tennyson. I don't think that's different than what I have in there in terms of whether the mitigating factors are sufficient to outweigh the aggravating factors, but I'll look further into that. But either way, I think all of the concepts in that line in your proposed instruction are covered. What else do you have?
I don't disagree with that, Your Honor, but I would ask the court to add beyond a reasonable doubt to the end of that sentence. Each juror must then individually decide whether the mitigating factors do not outweigh the aggravating factors beyond a reasonable doubt.
Actually, it probably should be each juror must then individually decide whether he or she is convinced beyond a reasonable doubt that any mitigating factors do not outweigh the proven aggravating factors.
That's actually even better, yes.
Okay?
And then at the bottom of page 6, here again we have the issue with this jury must return a sentencing verdict of life imprisonment without parole on that count. And when I looked at the statute, it seems to me that there is a difference the way the statute reads with respect to phase 1 versus phases 2 or 3. The statute does say that if, where is it? That in the event that no aggravators are found, the jury shall render a verdict of life imprisonment, but it doesn't have similar language with respect to phases 2 or 3. And in fact, in subsection 2D, it says if the jury's verdict is not unanimous, the jury shall be discharged and the court shall sentence the defendant to life imprisonment. So again, all of the jury's findings dictate the outcome of the sentencing proceeding, but it's not that the jury would be affirmatively rendering a verdict of life without parole. That would be the result of their findings. And so we would ask that it be rephrased to read that Mr. Holmes will receive a sentence of life without parole on that count.
All right, Mr. Orman.
I'm actually okay with that. Other than Mr. Holmes, I think it should be the defendant.
All right. So, and I am too. I just looked at the statute and it doesn't have similar language with respect to this phase of the proceedings, if you will. So it'll say otherwise the jury, how do you want it to read, Ms. Nelson? Otherwise?
I think we have some language, and again in our 46 about this, but it would
Well, you
be
just said it a moment ago, I think.
otherwise. Let's see here. Just give me just a moment. It would be at the bottom of our page 14, we say, if one or more jurors is not convinced, the sentencing hearing stops and Mr. Holmes, or the defendant, will be sentenced to life imprisonment without the possibility of parole.
All right, it will read like this. Otherwise, the sentencing hearing stops, and the court will sentence the defendant on that count to life imprisonment without the possibility of parole. Is that all right?
Yes, we would be, that's all right. Or simply Mr. Holmes will be sentenced, rather than the court imposing the sentence. Either one is fine with us.
Okay,
Um,
all right. What else?
Just a moment. Oh, and then again, we would ask, same request with respect to the language at the end of the description of phase 2, conveying to the jury that it's a perfectly valid verdict if this happens. There's no requirement that the proceeding go on to phase 3.
I mean, that's the same ruling as before. That's, we could do that in the guilt phase 2, right? We don't tell the jury, hey, it's okay if you return a verdict of not guilty. It's also okay if you return a verdict of guilty. I mean, it's understood, it is clear that they have to make a choice here, and we are providing them guidelines as to how they go about making the choice. So I don't think I need to tell them it's okay if you do it one way, it's okay if you conclude something different. So,
And just for the record, Your Honor,
Yeah.
our request for that is based on the heightened reliability that's required by the 8th Amendment in Colorado Constitution, Article 2, Section 20.
I understand, and there is a heightened level of reliability, and that's why I'm taking my time with this, and we're going sentence by sentence almost. I understand that. That's why we're taking so much time with this. That's why I'm letting you make all the objections that you need to make, tender all the instructions you want to tender, and we're having lengthy discussions about some pretty detailed things, because I understand that there's a heightened level of reliability that applies here, but I don't think it's necessary to tell them it's okay if you come back with, or if a life sentence is the end result. If I tell them that, I also have to tell them it's also okay if the end result is a death sentence. I can't just say one and not the other. It's similar to the other change that you were proposing with respect to one mitigating factor can outweigh all the aggravating factors. If I say that, then I also have to say, oh, conversely, one aggravating factor can outweigh all the mitigating factors. So what's next, Ms. Nelson?
Page 7, and now here we arrive at the issue that Mr. Orman raised earlier. With respect to that second paragraph, both moral judgment and mercy must be based upon the evidence and or information received during the trial.
Yes.
Our concern is that a juror's moral judgment doesn't have to be based on, moral judgment is something that comes from within. That's a person's morality. The person's morality doesn't have to be based on the evidence or information that they get during the trial. And so we had some concerns about that particular phrasing. And I went back and I looked at the way that the court addressed this issue in its video script, and we actually liked the way the court, I think it was actually with respect to phase 3, the way that the court addressed this. It's on page 8 and 9 of the court's video script, which is C-172A. And hang on a second. I think the court has similar language in phase 3. This actually might pertain more to phase 3 than phase 2. If I may just have a moment.
Okay. Well, we can take it out of phase 2 if you want, but actually, because we're talking about a moral judgment and mercy, I think it probably has to be addressed here too.
Well, actually, the way that The prosecution proposed, and their instructions were not numbered and don't have page numbers either. But I flagged the way that they described it in their instructions. Seemed to be less problematic from our perspective. Hang on a second. If the court substituted your ultimate decision for both moral judgment and mercy, that might take care of our concerns. I think that would take care of our concerns.
I'm not following you.
Okay.
I don't have the videotape remarks in front of me, so are you looking
Never
at,
mind. Forget the videotape remarks for a moment. I think that applies more to phase 3.
right,
So we're on page 7,
right?
second paragraph. Both moral judgment and mercy must be based upon evidence and or information received during the trial that I tell you may be considered and or during the sentencing hearing.
Right.
We would just ask the court, instead of saying both moral judgment and mercy must be based on evidence, instead say your ultimate decision must be based upon evidence and or information, etc. So just substitute your ultimate decision for both moral judgment and mercy.
Mr. Orman?
Well, it may be their ultimate decision, it may be their penultimate decision. It doesn't matter a great deal to me, but I think since we're mentioning moral judgment and mercy, this should be in here. Moral judgment, morality, I guess, is not necessarily based on evidence, certainly not the evidence in the trial, but the judgment is, and the application of mercy is. And I think that the way that the court has described it here on page 7 is correct and adequately and correctly would instruct the jury.
And, Your Honor, if the issue is your ultimate decision, it could read your ultimate decision in phase 2. But as an alternative, I would actually be better with the language that the prosecution proposed in their instructions versus the issue for us is including moral judgment as something that needs to be based on the evidence, because we think that a person's morality comes from within them and not from the evidence.
But this is not about their morality. This is their moral judgment that they make in this case to make their decision. It's talking about your reasoned moral judgment in making your decision in this case, or in deciding upon the sentence that you think is appropriate, or in this case in phase 2, in making a decision at the end of phase 2. That has to be based upon the evidence and or information received during the trial that I tell you may be considered or during the sentencing hearing. It can't just be in a vacuum. They can't say, you can't have someone as a juror say, nothing in the evidence or information presented in the courtroom leads me to exercise or to exercise my moral judgment and vote for a life sentence or to have mercy on the defendant. However, separate and apart from what was presented in this case, just on my own, I think I should have mercy, and I would have that mercy on any defendant. It has nothing to do with this defendant. It has nothing to do with this case. I think I'm a merciful person, and so I'm going to have mercy, and therefore I'm going to vote for a life sentence. That would be improper. That's why we took our time with jury selection, because that's exactly what jurors cannot do. They cannot come into this and say, forget the evidence, I'm going to ignore the evidence, I'm going to ignore the information presented in the courtroom, I'm going to ignore the instructions of the court, but just from my own morality, I vote against the death sentence. That's exactly what I told the jurors they could not do in voir dire, and that's consistent with the law. And so, because we're referring to moral judgment and mercy in the previous paragraph, I have to specify in the next paragraph that moral judgment and mercy has to be based on the evidence and or information received during the trial that I tell the jury it may consider and or during the sentencing hearing. Perhaps I should be more clear and say, and/or evidence and information received during the sentencing hearing.
So if the court is denying my request to rephrase to say your ultimate decision in phase 2 must be based upon evidence, then I would ask the court to consider taking a look at the way the prosecution phrased it, and this is their first phase 2 introductory instruction.
How did they phrase it?
A juror must use his or her individual reasoned moral judgment during phase 2 of the sentencing proceedings. Each juror may consider mercy for the defendant during phase 2, but mercy must be based upon evidence and or information you have received during they say guilt trial, but I would just say during the trial and or the sentencing hearing, and reflect an individual reasoned moral response to the defendant's background, character, history, and crime.
All right, Mr. Orman, what's the people's position with respect to that request?
Well, I think the court did better than me in drafting this, and I think the court's is better.
I like mine better as well, so I'm going to stick with it. All right, what else, Ms. Nelson?
If I may just have a moment, Your Honor.
Yes. And to the extent that some of your arguments and objections to the language in phase 2 refer also to or apply also to the language that I've used to describe phase 3, I would make the same rulings, but if you want to point them out specifically to me, I'm happy to address them.
Okay. On page 8, again, we would ask that count be changed to conviction pursuant to our merger argument.
Okay, same ruling on that issue.
And then our concern with, we have a concern with that language in that first paragraph on page 8 in terms of telling the jury that it can either return a unanimous verdict of life imprisonment without the possibility of parole or notify the court that it's not able to reach a unanimous verdict. I think we brought this up before. This was an argument that we made. I think
Yes.
this came up in the video script as well. So we would rely on the arguments that we made.
Well, tell me how you think it should be done. Do you think I should just tell them, should I just say nothing about that, or should I just say, in the event that you cannot reach a unanimous verdict, the court will sentence the defendant to life imprisonment? That's something that you told every prospective juror in individual voir dire, not you personally, but your colleagues.
But can I just have one moment, Your Honor?
Yes.
Yes, so if it should read, if the jury is not unanimously convinced beyond a reasonable doubt that death is the appropriate punishment on a particular count, the court will sentence the defendant to life imprisonment without parole on that count. And I think that's consistent with the statute as well.
Well, but that's not entirely correct. That's the problem. That's why I did it this way. Because one possibility of the jury not being unanimously convinced beyond a reasonable doubt that death is the appropriate sentence is that they are unanimously convinced beyond a reasonable doubt that life is the appropriate sentence, right? So...
But I don't think that the law and the statute doesn't distinguish between a unanimous life vote and a non-unanimous vote. Either way, the defendant receives a life sentence in that, under either set of circumstances.
Well, but what the statute says is that if the jury's verdict is not unanimous, the jury shall be discharged and the court shall sentence the defendant to life imprisonment. So the statute doesn't say if the jury is not unanimously agreed on a death sentence. It says if they can't reach a unanimous verdict, then what happens is that I am supposed to discharge them and then sentence the defendant myself to life imprisonment without the possibility of parole. But the jury is welcome to unanimously decide that life imprisonment without the possibility of parole is the appropriate sentence. And I want to make sure that they are clearly aware of that. So,
And I think our concern is just that it distinguishes and makes it seem somehow less, that they're somehow failing in their duties if they don't return a unanimous verdict on life. I mean, either verdict is perfectly valid, and so it just doesn't seem that we just don't see a reason for the distinction, and we think that there's a concern that if you distinguish between a unanimous verdict of life imprisonment and a non-unanimous verdict, that they're somehow going to get the impression that they need to be working towards a unanimous verdict when that's not the case.
all right, what's the people's position?
I think that the court has accurately described the process here, and the language should be as the court drafted it.
I don't have the concern that you have, Ms. Nelson. I don't see that from the language that I've used, so I'm going to stick with the language I have. What else do you have with respect to this particular instruction?
Would the court consider in that first paragraph on page 8, however, the jury may only return a verdict of death on account of murder in the first degree if each and every juror is convinced beyond a reasonable doubt rather than unanimously? Because it's an individual moral decision.
But isn't that what unanimous means? I mean, unanimous means they're all in agreement. They're all convinced beyond a reasonable doubt that death is the appropriate punishment, right?
But they have to get there individually by making an individual moral determination.
Right, but by saying the jury has to be unanimously convinced beyond a reasonable doubt that death is the appropriate sentence or punishment, it's saying all of you have to be convinced beyond a reasonable doubt that death is the appropriate punishment. So.
We understand, but it's again, we're trying to distinguish between the first trial and the second trial. In the first trial, they had to reach a unanimous verdict. In the second trial, they're making an individual moral determination. And if all of them, each and every one of them, agree based on their own individual moral determination that death is the appropriate penalty beyond reasonable doubt, then they can return such a verdict. But we'd prefer each and every juror. We would request that it state each and every juror for that reason.
If I may?
Yes.
I would just point out, I think this is covered in the first sentence on page 8. During the deliberations at the end of phase 3, each juror must individually determine the appropriate sentence on each count. So I think it says it 3 ways from Sunday, and we don't need to say it anymore.
Well, and the statute uses the language that I'm using or similar language, so I'm going to stick with this language. Ms. Nelson, what else do you have with respect to this instruction?
The bottom of page 8 and into page 9, same objection with respect to the moral judgment and mercy based on evidence.
Okay,
And-
same ruling.
Okay, well, and that's where we would propose that the court instead use its language from the video script on pages 8 to 9 of the video script.
But the reason I did it, I think in the video script, I think I was addressing mercy by itself and saying, look, you can have mercy for the defendant if you want, but it has to be based on the evidence and information presented in the courtroom. I think that's what it said. And I don't think I addressed a reasoned moral judgment, but clearly a reasoned moral judgment has to be based on the evidence and the information presented in the courtroom. It can't just be on something that they on their own decide to rely on that's not part of the proceedings, that's not part of what's being presented in the courtroom. It can't be from an outside source, and it can't be something that they bring into the case on their own, that they are relying on independent of what is presented in the courtroom and the law that I give them. So I continue to believe that this is the more specific and complete statement of the law.
And I think the paragraph that I'm referring to in the court's video instructions on pages 8 to 9 does address the same concepts it says, in reaching a verdict in phase 3, the jury must not be influenced by prejudice or bias. Further, the jury should not be swayed by mere sentiment, conjecture, sympathy, passion, public opinion, or public opinion or public feeling. Nor should the jury's decision be the result of an arbitrary or emotional response. Rather, each juror must apply his or her reasoned moral judgment in deciding whether, in light of the totality of the circumstances present, the situation calls for life imprisonment without the possibility of parole or the imposition of the death penalty. The jury may consider mercy and sympathy for Mr. Holmes, but the jury must ultimately make a factual and moral assessment of whether death or life imprisonment without parole is the appropriate punishment. The jury's verdict as to the appropriate sentence must be based on a profoundly moral evaluation of the defendant's character and crime.
And I have some of that here in the last paragraph. It says, with regard to each count, each juror must apply his or her reasoned moral judgment in deciding whether, in light of the totality of the circumstances present, the situation calls for life imprisonment without the possibility of parole or the imposition of the death penalty. As to each count, each juror must ultimately make a reasoned moral assessment of whether death or life imprisonment without parole is the appropriate punishment for the defendant on that count. The jury's sentencing verdict on each count must be based on a profoundly moral evaluation of the defendant's character and crime.
And actually, on page 9, I think the court was reading from page 9.
Right.
We would ask, our request would be that the court rephrase it as it's done in the video script, with the exception of, and this is just a final objection with respect to this instruction, the situation calls for life imprisonment without the possibility of parole or imposition of the death penalty. I think we objected to this in the video script as well. And I know that that's been used in some of the Colorado Supreme Court's case law, but the situation doesn't have to call for a life sentence. That's the default. And so we would ask that the court just rephrase and state, each juror must apply his or her reasoned moral judgment in deciding the sentence in this case in light of the totality of the circumstances present, period. The jury's verdict as to the appropriate sentence must be based on a profoundly moral evaluation of the defendant's character and crime.
Okay, I don't have a problem with doing that. So judgment in deciding the appropriate sentence in light of the totality of the circumstances present, period. Then the next line says, as to each count, each juror must ultimately make a reasoned moral assessment of whether death or life imprisonment without the possibility of parole is the appropriate punishment for the defendant on that count. The jury's sentencing verdict on each count must be based on a profoundly moral evaluation of the defendant's character and crime. Is that all right?
Yes.
Okay. The next instruction. Are there any objections from the people? By the way, in the next instruction, I replaced the paragraph that appears there with the paragraph that is at the beginning. So the initial paragraph is, I think, the one that I would prefer as opposed to the second paragraph. And so the new paragraph would read, in a sentencing hearing, the parties may rely on the evidence introduced during the trial that the court instructs you may be considered. Therefore, the prosecution may opt to proceed in phase 1 solely by presenting argument, although the defendant does not have a burden of proof in phase 1 or at any other time in a sentencing hearing. He may present evidence and or his attorneys may present argument. And this is to address points that I think both sides were making in their tender instructions. Mr. Orman, do you have any position as to that paragraph?
Your Honor, I like that paragraph. Can we go back to the previous instruction for a second?
Yes.
Because I think counsel forgot to mention their position on the evidence or information issue. It was sort of skipped over. So, and I don't know if...
Oh, that's true.
So I just think that we need to at least give the court both sides' positions on that.
All right, Ms. Nelson, thank you for reminding me.
We think it should be evidence and or information.
And do either of you want me to say anything to the jury in terms of what exactly information refers to, or just leave it as evidence and or information? That's number one. And number two, is either of you asking me that I talk to the jury about how in the first part of the proceedings during the trial, it was any decisions had to be based on the evidence, and I told them that, but now it can be based on the evidence and or information, or do you want me to just leave it just saying evidence and or information, Mr. Orman?
Well, I don't know that it matters for the introductory phase, but when we get to the final instructions for phase 2 and phase 3, I think that it will need to be clarified for the jury, because what does information mean? I mean, let's say they saw something in the gallery. That's not evidence, and certainly not information I think they're allowed to consider. So, but if they're just told information, they may think that it is. So I think for purposes of this phase, since they're not going to be making that decision necessarily based on information, I don't think it needs to be clarified, but later it probably will be.
All right, Ms. Nelson?
I think it should just be as stated.
All right, I'll leave it as stated for now because neither side is asking me to do anything different. But when we get to phase 2, Mr. Orman, if you think the court needs to explain, then I'll leave it to you to remind me about that, and then we'll have another discussion at that time. I do think that at some point I'm going to have to give them a more specific explanation, because I previously told them that when I said evidence and or information, or evidence and information, I simply meant evidence. And that's not entirely true at this point, given that the defendant can make an allocution statement. All right, so with respect to the next instruction, the one that I was talking about a moment ago, the people like it. What about the defense? Does the defense have any objection to the instruction about how the parties may proceed in phase 1?
And Your Honor, I'm sorry, just to go back again on the issue of evidence and or information, we just want to make it clear that we are not going to be telling the jury, and we're going to be objecting to telling the jury about Mr. Holmes electing not to allocute if he elects not to allocute. So if that affects the court's decision about whether to include and or information, we just wanted to make that clear.
Okay, that's fine. But in that case, then perhaps I just say evidence, and let's say he doesn't, let's say the defendant chooses not to make an allocution statement. In that case, I could tell the jury evidence and or information simply means evidence, the same thing I told them in the trial. Or if you can convince me that it means something else, then I can tell them something else. But
Okay.
we can cross that bridge when we get to it.
Okay.
But I'll leave it on you, counsel, to remind me about that, okay? All right, so with respect to this instruction, do you have any objection?
No, we think it's appropriate.
All right. The next instruction says, to the extent that I tell you that you may only consider certain evidence introduced during the trial for a limited purpose, you may only consider such evidence for the limited purpose that I tell you it may be considered. Similarly, to the extent that I tell you that you may only consider certain evidence introduced during the sentencing hearing for a limited purpose, you may only consider such evidence for the limited purpose that I tell you it may be considered. Any objection from the people?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
And the last instruction that I have in my set is the definition of reasonable doubt, and then it has some language that follows that I think both sides had, which is with respect to each count, the prosecution has the burden to establish that at least one of the 5 aggravating factors alleged has been proven beyond a reasonable doubt. The defendant has no burden of proof in phase 1 or at any point in a sentencing hearing. Any objection from the people?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
All right. Are there any other instructions that the people would like to have me give as part of my introductory instructions at the beginning of the sentencing hearing?
No, Your Honor.
Any other instructions the defense would like me to give the jury as part of my introductory instructions at the beginning of the sentencing hearing?
No, Your Honor, we stand on the record that we've made at this hearing.
Okay, great. So what I suggest is that we take a lunch break, and then we come back at 2, in almost an hour. Sheriff, does that give you enough time for lunch for Mr. Holmes? Okay, let's go ahead and do that then, and then we'll proceed with the videotape deposition, and then let's talk about the Curtis advisement at that point, and then the elocution advisement at that point as well, if we can, okay?
Yes, and just so the court's aware, we would like to get through a discussion of the introductory instructions to phase 2 before we start phase 1. It's my understanding that we have some witnesses that we need to get on Wednesday afternoon, and so we'd like to move right through phase 1 to phase 2. I think that they're pretty short. I think we only had a couple each.
You did, and frankly, now that we've gone through the introductory instructions, I think that sort of resolves a lot of the issues. I wanted to wait until we had this discussion, because then that would tell me how I was going to describe phase 2 for the jury, so it should make it pretty easy. So,
Okay.
All right?
And then I just wanted to tender these to your staff. I have marked a CD containing the defense's opening PowerPoint pursuant to the discussion we had on Thursday as CTR 88, and then a separate CD with our closing PowerPoint as CTR 89.
Okay. Mr. Orman?
And Your Honor, since we're going to go into introductory instructions for phase 2, I have an instruction I'd like to give to the court. I'm not asking to argue it now, but it's relating to the limiting instructions that were previously given regarding the evidence from the sanity examinations and the notebook. By statute, that information in phase 2, and phase 2 can be considered regarding the existence or non-existence of aggravating factors. So I have a proposed...
Mitigating factors.
I'm sorry, mitigating factors. I misspoke, Your Honor. I have a proposed instruction to provide to the court on that issue.
Okay. Yes, and if you would give a copy to Ms. Nelson, thank you. By the way, Ms. Nelson, we already have CR-88, so it should be 89 and 90. All right? All right, have a good lunch. I'll see you after lunch. The court will be in recess. Thank you.